was fully constituted. We had the chairman of GECOM, Justice Claudette Singh. We had Mr. Vincent Alexander, Mr. Corbin, and also Mr. Trotman, and that is Mr. Desmond Trotman and Mr. Charles Corbin. We also had Mr. C.S. Gunraj, Ms. Bibi Shadik, and Mr. Robeson Ben constituting the commission. And they were, again, the first meeting this morning focused on what they have described as a listening meeting. The chairman sat very quietly, as far as we know, and listened to all of her commissioners put forward their arguments, and then they took a break for lunch and met back this afternoon. They had a very, very short meeting, and after which we learned that the chairman has instructed the chief elections officer, who would have submitted a report, his elections report on Saturday last, to submit another report. And as you can remember, he had asked for some clarifications, and those clarifications have not been forthcoming. Nonetheless, he has been asked for another report, since the chairman does not like the advice that he has offered her in his last report. I think he has until 2 o'clock tomorrow afternoon to put that report to the commission. I want to walk you through some legislation that has impacted the chief elections officer's report, Mr. Keith Lowenfield. And for instance, he was asked to produce his report based on section 177 of the Constitution. And 177 tells us a couple of things. He says that after he has tendered his report, that the chairman of GECOM, Justice Claudette Singh, should declare, it says that shall be declared by the chairman of the Elections Commission, the results, that is, shall be declared by the chairman of the Elections Commission, acting only on the advice of the chief elections officer. She cannot ask for a legal opinion based on the advice he has tendered. She cannot proffer her own opinion, but acting only on the advice of the chief elections officer, she can afterwards make that declaration. And also we look to section 96, because as you remember, in her letter she says, based on section 177 of the Constitution and section 96 of the Representation of the People's Act, he must submit his report. And 96 of the Representation of the People Act tells us a couple of things. Is that it is based on valid votes, total number of valid votes, and who are these valid votes, or how do we get to valid votes? It says that this information is furnished by returning officers. If we can take it to that slide, that is section 96. Yes, there we have it. Total number of valid votes. Total number of valid votes. His report has to be based on this total number of valid votes. Who furnishes the chief elections officer with the total number of valid votes? And that person is the returning officers, who are part of that process of validating those very votes. And what else does section 96 tell us? It tells us that this shall be the basis of the commission declaring the results of the elections under section 99. These valid votes, as put together by the chief elections officer, who has received that information from the returning officers, a declaration can now be made by the commission on this basis. And as you know, as part of the national recount exercise, there were no returning officers. And this is part of the reason why the chief elections officer, Mr. Keith Lowenfield, asked for clarification, and again, none was offered to him. Another section of the legislation that impacts the chief elections officer's report, and we know this because the CCJ judgment itself referred to this when Justice Saunders talked about those persons who were part of this validating exercise. He referred to, or the court rather, the CCJ referred to section 86.1 of the Constitution. Thank you very much. 86.1 of the Constitution that tells us who are part of this validating exercise. Could we switch to the other one? Yes, and it tells us those persons who are eligible to be part of this exercise includes, again, the returning officer, members of the commission, duly appointed candidates, counting agents, and other such persons as are deemed necessary in the opinion of the returning officer. Note here, the returning officer has a huge role as part of the counting process, again, which validates the vote. And this is the CCJ that referred to this section, section 86.1. And again, in the Chief Elections Officer's letter asking for clarification, he notes this. He said, because when, Madam Chair, when you ask me for valid votes, and I go to what the law says stipulates as pertaining to valid votes, it does not include returning officers at the national recount. So I'm not clear which valid votes you want. Valid votes according to the national recount or valid votes according to 96 of the Constitution. So we get an appreciation as to why he has asked for clarification. And in the Chief Elections Officer's report that was tendered last Saturday, that one there, he set out, for instance, what were those valid votes according to his thinking based on law, 96 of the Constitution and 177. Andrew, he says that valid votes mean, these are the valid votes. For APNU AFC, 236,777, and for the PPP, we have 229,330. And if we go a little way down, we'll see how the seats, according to the Chief Elections Officer, were allocated. For APNU, 33 seats, and for the PPP, 31 seats, and for the joiner of lists mechanism, which is ANU, LBJ, and TNM, 1 seat. And so we have 65 seats there being allocated in the National Assembly. But I want to point us to some important things that the Caribbean Court of Justice judgment in this case tells us. And clearly the OAS has not read this report, this judgment. Clearly the OAS has not read this judgment, because they would not be making some of the statements that they have been making. For instance, the Caribbean Court of Justice tells us that it is the exclusive jurisdiction of the High Court through 163 to determine, among other matters, any questions relating to whether the election has been lawfully conducted or the results affected by any unlawful act or omission naturally unaffected by Order 60. Basically, if you have contention with the results of the election, you have to go to an election petition afterwards. So that's one important thing that the Caribbean Court of Justice told us in their judgment. What else did the Caribbean Court of Justice tell us? Remember, the chairman of the Guyana Elections Commission is asking for valid votes. And here is what the judgment told us about valid votes. They said validity in the context means and could only mean those votes that ex facie are valid. The determination of such validity is a transparent exercise that weeds out of the process, for example, spoiled and rejected ballots. This is an exercise conducted in the presence of inter alia, the duly appointed candidates and counting agents of contesting parties. Good. It is after such invalid votes are weeded out that the remaining valid votes count towards the determination not only of the members of the National Assembly, but incidentally as well to the various listed presidential candidates. Now, when you hear the CCJ says this, you're going to think in your mind they're talking about the recount process, but in actuality they are not, because in the judgment after this very section here, they point us to the Representation of the People Act at 86.1, and it is that section which we talked about a little earlier when we talked about those persons who are part of this validating process of the votes. For instance, the presiding officer. And again, it was the Chief Elections Officer who told us at the national recount, no presiding officers were present there. So it couldn't be the national recounts, quote-unquote, valid votes that the CCJ was referring to, because, again, they pointed specifically to 86.1 of the Representation of the People Act and those persons who are entitled to be part of this process of validating the votes, which chiefly is the returning officer who is in charge of that show there. But the most important thing that the Caribbean Court of Justice judgment tells us, and I want you to really understand this part, especially the OAS Mr. Hilary Beckles, and all the other persons who are talking about the recount order, because the recount order has one quote-unquote set of valid votes, and again, the 96 of the Constitution tells us about a different set of valid votes, of which you have a validating process that is led by the returning officer. This is what the Caribbean Court of Justice tells us. It says the court also notes that an order issued by GECOM in any particular context can never determine how the Constitution is to be interpreted. It is a matter of elementary constitutional law that if ordinary legislation is in tension with the Constitution, then the courts must give precedence to the words of the Constitution and not the other way around. With respect to the notion that the Order 60, which is the gazetted order, could either impact the interpretation of the Constitution or create a new election regime at variance that clashes with the plain words of the Constitution, this is constitutionally unacceptable. So clearly, valid votes based on the national recount and valid votes based on Section 96 of the Constitution are two issues that are clashing. And so in this context, the CCJ tells us that where there's a contention or there's a clash, the Constitution must take preeminence, which is why the Chief Elections Officer went back to those 10 declarations as of March 2nd, 2020. But something else happened that the Caribbean Court told us about. They issued no coercive declarations in that judgment. And I want to read that section clearly for you. It says here that the court's jurisdiction has been invoked for the purpose of determining whether the Court of Appeal lacked jurisdiction to entertain Ms. Eslyn David's application to make the orders it made. Once we decide that the Court of Appeal's order was made without jurisdiction and should therefore be set aside, there is nothing left upon which we ourselves would possess jurisdiction to make any further orders. The court went on to state, to accept counsel's suggestion, this is the PPP folks, to accept counsel's suggestion and proceed down that path would be to engage in an exercise not dissimilar from the one embraced by the Court of Appeal's majority and which we have eschewed. It is for GECOM, this is the Caribbean Court of Justice, who says it is for GECOM to ensure that the election results are swiftly declared, Madam Chairman, in accordance with the laws of Guyana. Again, it is for GECOM to ensure that the results of the elections are swiftly declared in accordance to the laws of Guyana. And this is where we are tonight. Again,